Once a petition for divorce has been filed, the respondent has 20 days from the date of being served to file an answer with the court if they reside in Manitoba. If the respondent lives in Canada but outside Manitoba or in the United States of America, they have 40 days to file an answer. If the respondent lives outside of Canada and the United States of America, they have 60 days to file an answer. If the respondent has not filed an answer within the time prescribed by the Queen's Bench rules, you may file your affidavit of service and a requisition noting default on the respondent. This allows you to proceed with the petition for divorce on an uncontested basis and schedule your divorce on a hearing list using Form 4E, the requisition. You will have the option of proceeding with your divorce as an affidavit divorce, which involves providing the court with the necessary evidence for your divorce in document form, or you can choose to have an uncontested hearing that would require that you attend court and provide your evidence in person. Children are an important factor that must be considered when deciding between an affidavit divorce and an uncontested divorce by way of a court hearing in front of a judge. When a petition for divorce is filed and there are children listed who are under the age of 18 or over the age of 18 and still dependent, the Divorce Act and regulations require the judge to consider the sufficiency of child support in accordance with the child support guidelines. This mandatorily requires that the court be provided copies of the paying parent's last 3 income tax returns and proof of current income, which can take the form of 3 recent and consecutive pay statements. These documents must be attached as exhibits to your affidavit of petitioner's evidence. If you choose to proceed by way of a court hearing, financial evidence can be presented in court. If you're proceeding with an affidavit divorce, you will be required to file the completed affidavit of petitioner's evidence, 3 divorce judgments, 1 pre-stamped addressed envelope for each of the parties, possibly a final order. The affidavit of petitioner's evidence must be sworn or affirmed before an authority such as a Queen's Bench Deputy Registrar, a Commissioner of Oaths, or a Notary Public. It is important to ensure that the exhibits mentioned in the affidavit are attached and verified by the authority who witnesses the signing of the affidavit. When exhibits or the appropriate financial documents have not been attached to the affidavit of petitioner's evidence, a notice of rejection is issued and the divorce does not proceed until the requirements have been fulfilled. The divorce judgment is the document that the judge will sign. A few tips to assist in preparing this document include: use the full names of each party at each instance. The names should be identical to how they appear in the petition for divorce. Don't abbreviate any words or dates. Don't use whiteout. If preparing by hand, print clearly. See the included sample to aid in the preparation of your document. There are circumstances that require a final order to be prepared and submitted with the divorce judgment. When a petition for divorce is filed, and under paragraph 1 there are items of relief other than the request for a divorce that have been checked off, such as custody, child support, or spousal support, the court rules require that an order be pronounced dealing with all the relief pled. If you are no longer seeking any such relief, an order still needs to be filed dismissing, withdrawing, or adjourning this relief. Once a divorce has been granted by a judge and the divorce judgment has been signed, you can expect to receive your copy in the mail approximately 10 to 20 days following the signing of the divorce judgment. In most cases, a divorce becomes final on the 31st day following the granting of the divorce. After the 31-day appeal period has lapsed, a certificate of divorce can be obtained from the court office where the divorce was granted by appearing in person or by mail. Currently, the fee for a certificate of divorce is $20.